Thanks for listening to The Professional Edge. My name's Sean Todd, tax attorney, CPA, and certified financial planner. Getting excited about the holidays coming up, and you should too. We're going to get together with families, and that's a great time to actually sit back, consider what your estate plan document actually says. And unfortunately, half of all Americans don't have any estate planning in place. So that's the wake-up call. We only have 2 months left in 2021 to get our New Year's resolution for 2021 done. And getting it done is actually getting your estate plan done properly. That is not downloading a document from the internet and thinking that that's going to matter and take care of everything. And that's the reason for the show is not completely true, avoiding estate planning gotchas. So we talked about titles, we talked about beneficiary designations, we talked about life insurance beneficiary designations, and how those supersede and prevent the terms and conditions of the last will and testament from applying. So to have a candid conversation to make sure that your estate plan is true and correct and actually updated to the current provisions, give our office a call at 877-654-9798. That number again, 877-654-9798. The other great place to get started, a lot of people don't want to pick up the phone. They would rather just type on the computer. So go ahead and type EMC Advisors, emcadvisors.com. And on the right-hand side, there's the Ultimate Estate Planning Guide. Put your information in there, and we'll send that out to you gratis of postage. Yes, we'll even cover the postage because, I believe that all our listeners here on the Professional Edge need to have their estate plan done. I am very passionate about this. We know you're not getting out of this alive. The fountain of youth has not been discovered. So we're going to use this eventually. And just because you sign your estate planning documents doesn't mean that you're going to use it tomorrow or even next week or even this calendar year. But unfortunate things happen to good people, and the timing of that is also significant, and it's not normally planned. So make sure that your estate plan is in place. And again, give our office a call at 877-654-9798. That number again, 877-654-9798. So let's go to the next topic that we've seen and not completely true. Well, we talked about the individual that had their property here in the state of Georgia, and they had the condo down in Florida on the Panhandle. The husband had that condo in his name. He passed away. His last will and testament said, "I give everything to my surviving spouse." Surviving spouse doesn't really like PCB area of the Panhandle. She wants to move to Destin. She has a quick sale, quick buyer, and unfortunately, she is not going to be able to convey that title immediately because we need to probate the will, and because there's real property in the state of Florida, we're going to have an ancillary probate estate to probate the condo in Florida. And Florida statute says that an individual cannot probate their estate, but you must have an attorney. So the not completely true, that means that we're going to have some time delay, 9 months to 2 years to probate an average estate. I'm going to have now 2 attorneys. You can probate it up here in Georgia alone, but in Florida, you are required by state statute that you're going to have to engage counsel. So now you got 2 attorneys talking together, and by the chance of the probability of being able to sell this to that urgent buyer, probably going to dissipate and not going to be able to be completed. So not completely true that you're going to be able to convey title within the next week after the person passes away. But let's change that and see what a different estate plan would do. Well, let's modify this, the estate planning document being a revocable living trust. Husband had the name of the condo in his trust in Florida and named his wife as being the successor trustee on his trust. Well, lo and behold, husband passed away, same plan of distribution, meaning all to my surviving spouse. Well, she walks in and she signs another deed transferring it from his trust to her trust, or even to her individually. Lo and behold, that can be done as soon as that death certificate is issued from the Department of Health. That could be within a week. And yes, she can convey title. She's not subject to the terms and conditions of the probate court. because there is no ancillary probate when we utilize a revocable living trust as the primary planning document for your estate plan. So again, if you're a listener here on the Professional Edge and you are fortunate enough to own that down at Gulf Shores, Alabama, or you're in the Panhandle and you have title to that property in your individual name, you have a last will and testament, well, lo and behold, your estate is going to be the lucky winner of ancillary probate. That again is probate in your domicile state and then probate where that real property is located. So again, if you want to avoid that, then we establish a revocable living trust, change title to the condo into the name of your trust. So when you pass away, there is no ancillary probate, there is no probate delay, and actually you don't even have to engage an attorney to do anything with that trust. You can actually prepare a deed, that's all their services is going to need, to transfer that condo from the decedent's trust to the surviving spouse's trust. Boom, we're done. There is no probate of that property down in Florida. So again, not completely true. When you have a last will and testament, that is a do not pass go directly to probate. With real property outside your domicile state, you're going to have an ancillary probate. Now, if you have a bank account in that state, then those terms and conditions are going to apply there. But the real zinger is when there's real property outside your domicile state, you're going to have to probate that in the county in which your real property is located. So again, not completely true that you're going to be able to access the assets immediately upon the passing of an individual. Again, it's 9 months to 2 years delay. And then we're going to have two attorneys talking. And you and I both know when two attorneys talk and they get paid by the hour, they talk real slow. So if you want to avoid that and take advantage of what we put together here at Estate Management Counselors, it's called the bundle. We have combined the estate plan. We have combined your income tax plan, not just your tax preparation. Tax planning is completely different. Being a tax attorney and a CPA, when was the last time you actually sat down and planned your taxes? So again, we've combined your estate plan, your tax plan, and your portfolio review all in one service, and that's called the bundle. If you would engage us independently for each one of those, it would be north of $10,000. What we've done is actually for listeners here on the Professional Edge is combine that together for a discount of $3,000. Yes, $3,000. There is no inflation in on this. It is actually deflation. I'm giving you a huge incentive to get in place your estate plan, your tax plan, so we don't send more money to the IRS than legally necessary, and to make sure your portfolio is reviewed and adjusted given the huge jump in inflation, the largest jump in the past 30 years. You've seen it at the gas station. I've seen it at the grocery. So it's amazing how prices have jumped. So again, the combination of those three is $3,000. The details, visit emcthebundle.com. That is Echo Mary Charlie thebundle.com. So what's the next thing that we need to think about on Not Completely True on estate planning gotchas? Well, we talked about the individual having a name on the account that's going to go to their daughter, the named beneficiary on that account, not really the name beneficiary, just the joint account holder. So going back to that scenario, a lot of our listeners here add one of their children onto their bank accounts. And we know that unfortunately, marriages are not staying together as long. So the daughter's been married and then all of a sudden the daughter's getting divorced. And, mom and dad weren't too happy with the son-in-law anyway, and they're sort of happy that he's getting away. Well, the son-in-law wants to be a complete piece of work. You know who I'm referring to. So the individual then says, list your assets out on your marital balance sheet. Well, the daughter doesn't even think about adding the account that's actually mom and dad's. Well, through discovery, there's a bank statement which comes through, and it is mom, dad, and daughter. well, then there's a big discussion on whether daughter is actually being truthful or not, because she never disclosed this on the marital balance sheet when she was in the midst of the divorce. Well, the soon-to-be ex-husband's going to challenge that all day long because there's $150,000, and being on title to that account of mom and dad's, she actually has legal interest, and she can actually walk in one day and withdraw $150,000. So the argument ensues that part of that account or all of that account should be considered as part of the daughter's assets. So that's just another thing which not completely true. Well, she's going to argue that none of those assets are hers. They shouldn't be counted, and therefore we shouldn't even be discussing that. But that's not completely true. The courts somehow believe there's equity. And what is equity? Well, that's their own definition on whether they got a lot of sleep the night before or not. That's equity. And they're going to divide that. And if they've had bad night's sleep and they sort of like the ex-husband or soon-to-be ex-husband over the daughter, well, guess what? They can pull part of that account or even have the entire account balance as an offset for the daughter's assets. And you just scratch your head a second for that, okay? It's happened. The judge has actually put that value in on the daughter's side, even though the daughter has made zero contribution, would never take that money from mom and dad for her own. It's all there for convenience. So again, this convenience could be very costly. So these are the things that being a tax attorney, a CPA, a certified financial planner, that we actually look at our office, being trained in these three disciplines to make sure that our clients are taken care of. I understand why you add your son or daughter to that bank account to give them access to those dollars to pay bills, but let's do it properly. Let's remove them from the account. Let's draft a specific estate planning document, put that in place. If they need access to the account, they're going to act through a legal document, but now that account is never going to be exposed to potential claims of creditors of your son or daughter that's on that account. And the largest potential creditor is your ex-spouse. So hopefully we have covered a lot of things which may just put you at unease. I don't want you to be cavalier about this because the consequences are dire. So again, not completely true. Estate planning gotchas. Let's avoid these going forward. I appreciate your time listening to The Professional Edge. If somebody's getting ready to go through a divorce, send this session over to them on our podcast. Again, you can find us on Apple, on Google. It's the show name. All you got to do is search for it is The Professional Edge. My name's C. Todd. I appreciate you listening in. Tax attorney, CPA, certified financial planner. Got to make the most of each day because tomorrow's not guaranteed. And I appreciate you listening in.